Law 529, Law of Evidence 1, the topic on Similar Facts Evidence, Lecture 3. In this video, I am going to explain to you the position of Similar Facts Evidence or SFE under the Evidence Act 1950. Now, Similar Facts Evidence is basically not expressly mentioned in the Evidence Act 1950. However, similar facts evidence have been used by the courts in Malaysia, and the court basically applied similar facts evidence under Section 11, 14 and 15 of the Evidence Act. By looking at this PowerPoint here, in particular, similar facts evidence have been taken in Malaysia, has been used in Malaysia pursuant to Section 11, subsection B of the Evidence Act. Of course, you have there Section 14 and 15 of the Evidence Act. Now, let's look at the position under Section 11. Now, when you talk about Section 11, now let's read Section 11. Section 11, facts not otherwise relevant become relevant. Facts not otherwise relevant are relevant if they are inconsistent with any facts in issue or relevant fact. Subsection B, if by themselves or in connection with other facts they make the existence or non-existence of any facts in issue or relevant fact highly probable or improbable. Now, Section 11 here is known to be a residuary section, and you are tendering evidence basically which are not relevant to the facts in issue. It is generally not relevant to the facts in issue, but it can be tendered as evidence in the court. It becomes relevant because the fact that it is not relevant, it becomes relevant. Say, for example, you have an illustration. Yeah, we are looking at Section 11, subsection A. Section 11, subsection A, by looking at the illustration, is basically talking about you tendering an evidence of alibi. Say A is charged for the murder of B. The facts in issue that A killed B is by stabbing. Say, for example, it happens on the 1st of January 2020. It happens at Section 7 Shah Alam, where A stabbed B. That is the facts in issue. The body of B was found in Shah Alam. You basically find a knife there and related evidence of murder, which happens in Shah Alam. Now, when you talk about Section 11, subsection A here, as I told you just now, we are talking about defense of alibi. What transpired in Penang is generally not related to the facts in issue of whether A killed B. However, if A is raising alibi, he is basically saying that he is not here at the scene of the crime, he is somewhere else. So what transpired in Penang, which is generally not relevant, not related to the facts in issue, now becomes relevant and related to the facts in issue. So the incident that happens in Penang, say for example here A is giving evidence of the fact or a photograph of the fact that on that particular day when A killed B, A was in Penang perhaps together with the mother. So you are tendering evidence of the photograph. They are having dinner at home with the mother and producing the evidence of maybe his flight ticket to Penang. This will become relevant. So the evidence which is in Penang, which is inconsistent to the facts in issue that happens in Shah Alam, becomes relevant and admissible. So this is where you are looking at that A is claiming the fact that I'm not at the scene of the crime, I am in Penang. So the evidence of what transpired in Penang here becomes relevant and it can be tendered under Section 11, subsection A. So this is actually a residuary section under Section 11. So this is not where you are bringing in similar facts evidence. Under Section 11, the court has brought similar facts evidence basically under Section 11, subsection B of the Evidence Act. Now, usually the court under Section 11, subsection B of the Evidence Act have been using this provision to bring similar facts evidence basically to establish the actor's risk. Now, let's look at Section 11, subsection B. This is basically the residuary section which I'm talking about. Now, if by themselves facts not otherwise relevant are relevant if by themselves or in connection with other facts they make the existence or non-existence of any facts, an issue or relevant fact highly probable or improbable. Now, the courts in Malaysia has been bringing in similar facts evidence under this provision, and you basically have this in the case of R.V. Raju. So, an example of cases in which similar facts evidence has been taken under this provision is the case of R.V. Raju. You have also other cases that talk about similar facts evidence by bringing in by a through section 11 subsection B. Now, what happened in the case of R.V. Raju is that when the court bring in similar facts evidence, the court basically has used the fact that if you are to tender evidence under section 11, right, the evidence that you tender must be specific to the purpose, number one, to negative accident, right? Okay, you are tendering evidence under section 11 to prove identity, to prove intention, to rebut a defense. To rebut a defense. So if you look at the notes here, similar facts evidence have been brought in by the court under section 11 subsection B here, basically by using the categorization in making, right? So if you recall back, when we refer to the special categorization test as introduced in making says that you can tender evidence if it falls under one of the following purposes, that is basically to negate accident, to prove identity, to show intention, or to rebut a defense. So the court basically indirectly apply the similar facts evidence test in making to bring it under section 11 subsection B of the Evidence Act. Okay. Now, the second provision in which the court accepts similar facts evidence is by looking at section 14. Now, let's look at section 14. Again, when you read section 14 of the Evidence Act, there is not a single word that has been used to reflect it to be similar facts evidence. Section 14, facts showing existence of state of mind or body or bodily feeling. Facts showing the existence of any state of mind such as intention, knowledge, good faith, negligence, rashness, ill will or goodwill towards any particular person, or showing the existence of any state of body or bodily feeling are relevant when the existence of any such state of mind or body or bodily feeling is an issue or relevant. So if you look at section 14 here, you'll find that section 14 here is basically divided into two parts. Number one is you tendering similar facts evidence to reflect the state of mind. For example, knowledge, intention, reckless, negligence, and ill will. So this actually is it falls squarely within the context of categorization that is actually introduced in making, whereby you are talking about the state of mind. When you talk about making last time, remember, one of the purpose of you tendering similar facts evidence is to show intention or the state of mind. So section 14, the first part of section 14 that allows for the tendering of similar facts evidence, which is number one, to reflect the state of mind. And number two, under section 14, you are tendering evidence to reflect the state of body or bodily feeling. Now, what does it mean by state of body or bodily feeling is actually not defined by any case law. And further, when you refer to explanation number 1 to section 14, you'll find that in explanation 1, a fact relevant as showing the existence of a relevant state of mind must show that the state of mind exists not generally but in reference to the particular matter in question. Right? So basically, when you talk about evidence of state of mind, State of mind must be specific. It has to be specific to a particular matter. You cannot give evidence that reflects state of mind which is of general in nature. If the state of mind reflects intention to kill, then it has to be specifically to kill. You cannot have general state of mind, meaning to say specifically to kill A. You cannot have general state of mind like intention to kill, in general. And when we refer to explanation 2 to section 14, you find that, but whereupon the trial of a person accused of an offense, the previous commission by the accused of an offense is relevant within the meaning of this section, the previous conviction of that person shall also be a relevant fact. So it means that under explanation 2 to section 14, previous commission of crime can be produced to show evidence of similar facts, to show the existence of the state of mind as to the commission of crime. And when you talk about previous commission is basically much more general compared to previous conviction. You can also bring previous conviction of an accused person under section 14 explanation number 2, and if you are bringing in the previous conviction of a crime, you have to cross-refer to evidence of character, which is under section 54 subsection 2 subsection A, right? So previous commission is much more general, but it can still be brought in. Say for example, you have an accused person has been assaulting the wife, and the wife have been making complaint to the police station, and eventually the facts and issue here is whether the accused person killed the second wife. The fact that the first wife has been making complaints reflect the existence of previous commission of assault, so you can tender that complaint under similar facts evidence. Okay, now. And the last one will be the one under section 15 of the Evidence Act. Now let's illustrate, now let's look at the provision in a greater detail. Now when you talk about section 14, of the Evidence Act, so when you talk about section 14 of the Evidence Act, section 14 of the Evidence Act basically says that you can tender evidence to reflect state of mind or state of body or bodily feeling. So when you talk about state of mind, of course, as I told you earlier, this falls within the categorization of making, that is to show intention, and in the context of section 14, you are talking about the state of mind of being, having intention, negligence, knowledge, goodwill, ill will, rashness, and so on. And the case to illustrate to you the position or the existence of state of mind under section 14, we can basically look at a Singaporean case of Anthony LAW529. Now what happened in this case is that, so you have the case of Anthony. Now what happened in this case is that you have an accused person. So you have an accused person here who is actually in the process of having a divorce with the wife. So he is actually in financial difficulties and has a girlfriend. So he has a girlfriend, and he is basically trying to kill the wife. So what happened here is that he has approached another accused person. Okay, I name him F, G, and H to commit the crime. So what happened here is that A here, the accused person here, which is Anthony, has been making plans as to how the murder should be done. So A has basically cited the plan and asked F, G, and H here to commit the crime, in which, say for example, he purchased from them a weapon and planning to kill them, in which he will ask the wife out, and then he left the wife, and then the accused person F, G, and H here will ambush and kill the wife, unknowingly. So when when F, G and H here in the first attempt trying to do that, it failed because suddenly they decided not to commit the murder, and A again approached them for the second time, and the murder took place upon the second attempt. So when eventually the police conduct investigation, the evidence given by F, G and H here basically says that the person who planned the commission of the crime and which reflects basically the conspiracy to commit the crimes is basically A. So A now here is charged for murder, and the evidence of the accused state of mind. So what A said relating to his state of mind of wanting to kill the wife was when he said it to the girlfriend, and when he said it to the friend F, G and H here are all taken in by the court under similar facts evidence section 14 of the Evidence Act to reflect the state of mind. So even though the accused person here did not commit the act of killing, the intention to kill or the position or what he has in his mind has been taken by evidence related by other persons relating to what he said with regards to his intention, and the court has used this evidence under section 14 to reflect the state of mind. Now, another provisions in which similar facts evidence is taken is basically under section 14 of the Evidence Act under section 15 of the Evidence Act 1915. Now, if you read the provision of section 15 here, again, as I told you, it is not specifically referred to similar facts evidence, but in between reading section 15, you find that you can basically see or incorporate making. You can also look at striking similarity by reading the underlying of section 15. Now, let's look at section 15. Facts bearing on question whether act was accidental or intentional. Where there is a question whether an act was accidental or intentional or done with a particular knowledge or intention, the fact that the act formed part of series of similar occurrences in each of which the person doing the act was concerned are relevant. Basically, if you read section 15, there are three conditions in which you can apply section 15. Number one, whether the act was accidental or intentional or done with a particular knowledge or intention. So the first part of section 15 basically talking about what section 14 is talking about. That is the position of the state of mind, and in this context we are talking about the state of mind of accidental or intentional or done with a particular knowledge or intention. Again, by looking at the special categorization test in making, you are talking about making purpose, that is to show accident or to show intention. So the first part of section 15, which talk about the state of mind, is basically reflective of making special categorization test. Right? The second condition under section 15 is that issue must form part of series of similar occurrences. Now, when we talk about part of series of similar occurrences, again, we can see the use of making special categorization tests that is show system or design, because you are looking at series of similar occurrences. So when you talk about system last time and we talk about design, you are repeating the thing again and again and again, and it is similar in nature. That is where you are applying making tests of system. Or also you can see the operation of striking similarity test by looking at the words of series of similar occurrences. You remember when we look at the test of striking similarity, remember the modus operandi as to how the commission, how the crime is committed is strikingly similar. So you have series of similar occurrences. So this part actually fit into the striking similarity test as introduced in Sims and Smith. And this series of similar occurrences basically involve the same person. Alright? Right, so what can we say about section 15 is that, so when you talk about section 15 of the Evidence Act, right, section 15 of the Evidence Act also have two categorization, or can be divided into two, with of course strict condition. Number one, it prove the existence of state of mind, and number two, you can also see series of similar occurrences. And number three, this incident, series of similar occurrences involve that particular person, the same person. You are talking about the same person. It's actually committed by the same accused person. Well, remember, so basically when we refer to the Evidence Act, you have to bear in mind, our Evidence Act was actually created way back before 1950. Even though the Act, it was initially an evidence ordinance. Of course, in 1950, it was made into an Evidence Act. And our Evidence Act 1950 here is incorporating the common law position in the UK as practiced in India of the 18th century. So at that time, when Sir James Stephen created the Evidence Act, what we have in relation to the similar facts evidence, what we have only the Makins test, right? So basically, Section 14 and 15 of the Evidence Act, which was cooperating the position of the common law of the 18th century, is basically incorporating Makins' special categorization test. And of course, it is extended perhaps to the use of striking similarity test. Okay? So, now when we look at this one, right, you look at the first one, the Act, under Section 15, the Act was accidental, intentional, or done with a particular knowledge or intention. So you are basically looking into the Makin special categorization test to reflect state of mind, intention, to rebut an accident, and so on and so forth, which we have discussed in Makin's test. And when we talk about series of similar occurrences here, as I told you earlier, we are looking at the striking similarity test. We can apply striking similarity test. We can also apply the existence of a system, right? And bear in mind, say for example, you have a situation, So you have a situation, say, A, the facts in issue here is whether A killed B. The facts in issue here is whether A killed B. This happened on the 1st of January 2020, right? And A has committed some kind of an offense, a similar offense in 2000, where he was charged but not amounting to an acquittal of a victim V. The modus operandi in which offense is committed is that B is the secretary. The murder happened at a hotel room where B was murdered by stabbed, and there was a black rose, put at the side of the victim. Similarly, in 2000, similar incident happened. The victim is the secretary of A, but the murder happened perhaps in a rest house, right? It is by stabbing, and there was a black rose. So the incident here happened. The facts in issue here is whether A killed B in 2020. The fact that can the prosecutor bring the incident of murder which happens in 2000 to prove that A committed the crime. Now, if we can basically apply the common law position, you can apply Makin's test here, you can apply striking similarity test here, you can apply property value test here, and in the context of Malaysia, you can also apply in Malaysian position. You apply section 14, the existence of state of mind, that is this the incident that happened may reflect intention. You can also apply section 15 here. You have the state of mind, you have series of similar occurrences, and it is done by perhaps the same person. So here what you did is that you are going to use section 14 and 15 of the Evidence Act and apply the common law test to reflect the operation of section 14 and 15. Right? Now, the use of similar facts evidence in section 14 and 15 has been applied by the case. There are several cases in which the court applied SFE in Malaysia. You have the case of Viren Kuti, and of course the case of Junaidi. What happened in the case of Junaidi here is that you have an accused person here being charged for a use of firearm. He was charged for having possession and use of firearm to commit robbery. The incident, the similar facts evidence that has been applied in this case is that 3 months while committing the robbery, the accused person was seen to have had within his possession a revolver. So when he was later charged and having no possession in his revolver, what happened here is that the defense in this case is saying that, right, the lawyer for the accused person is saying that you are not catching him with a revolver in his hand. You basically cannot sustain the claim of possession of firearm. And in this case, the court has applied similar facts evidence saying that since you have committed the robbery 3 months ago and you have a revolver in your hand, you therefore has that possession of firearm. So he basically was charged and convicted for possession of revolver, and similar facts evidence has been applied. Right? So here similar facts evidence has been applied by applying the striking similarity test. You can also invoke the special categorization test in Makin that reflects system, right? And of course, in this case, the court has incorporated the use of the probative value test. The probative value test. The probative value test. So basically, this case is the case that incorporated the Bodman's probative value test in Malaysia. You have to bear in mind that Bodman test was decided in 1970s. It is way after the Evidence Act has been created. And if you look at the cut-off date in which the Evidence Act is to be applied, it has to be before the cut-off date for the common law to be automatically applied in Malaysia. But the Bodman test here was basically introduced in 1970s, and it has to be incorporated in Malaysia by the decision of the court, and Junaidi was the case that incorporated Bodman into the Malaysian system. So by virtue of Bodman test here, what we have here is that the court is basically analysing the facts in Junaidi using the probative value test outweighs the prejudicial effect. And by virtue of this, what happened here is that subsequent cases to this, we have the case of Azahan. We have the case of Azahan, in which the court used the probative value test in disallowing similar facts evidence. Now, what happened in Azahan is that you have an accused person here committed the rape. He raped daughter number 1, and he is also raping daughter number 2. He raped both of the daughters, and the incidence of rape that is illustrated by daughter number 1 is used to reflect striking similarity of rape of daughter number 2. And in this case, the issue here is that the prosecutor wants to bring in the evidence of rape of the first girl to the second girl, right? So you have here different victims, similar occurrences. However, in the case of Azahan, the court basically applied the probative value test, and in this case, the court rejected the evidence of similar facts evidence on the ground that it is highly prejudicial. Why was it highly prejudicial? Because in Azahan's case, the court is basically looking at the whole circumstances of the case, and the whole circumstances of the case is that, in this case, the prosecutor really has taken advantage of the accused person who was not represented, and the prosecutor in this case has amended the charge more than 5 times, right? And the fact that the accused person is unrepresented at that time, so the court has considered these factors to be highly prejudicial on the accused person. Therefore, the court says that by applying the Bodman test, the probative value may be high, but the prejudicial effect is equally high. Therefore, similar facts evidence was rejected in Azahan, right? So Azahan was the case where the test of Bodman applied to reject similar facts evidence. Okay, and of course, if you look at other example, if you look at here, the case of Ahmad Firdaus is also the case in which the court applied property value test in Malaysia and put it within the provision of section 14 and 15 of the Evidence Act. So what happened here is that the similar facts evidence is basically quite difficult to prove. You have to have series of repeated commission of a crime, the modus operandi, and once you have that, someone has to be able to testify the existence of repetition or repeated acts or repeated modus operandi, right, to reflect the existence of similar facts evidence. Bear in mind that similar facts evidence was attempted to be tendered in the case of Padmanathan, that is the death of Susilawati, but it was difficult to prove. Yeah. Otherwise, if you have all the elements of similar facts evidence there, you can apply the probative value test. Of course, similar facts evidence can be tendered and has been tendered in Malaysia. For example, what happened in the case of PP against Ahmad Firdaus. The manner in which the accused person has been committing the crime by packaging the drug in the same way and keeping it in boxes the same way, the court says that this is reflective of similar facts evidence. So what you got to do is that if you are to apply similar facts evidence in the court, you just mention the provision, the Evidence Act, you have section 11, subsection B, or that is more directly applying similar facts evidence, which is will be section 14 and 15 of the Evidence Act, and you incorporate the position of common law test to reflect the existence of similar facts evidence. Okay, by this note, we complete the topic of similar facts evidence.